London, a courtroom, wood-panelled walls, dozens of journalists watching every blink, every twitch. And at the centre of it all sits Prince Harry, visibly tense.
It shows they've lost faith in his case. One legal analyst said that when solicitors walk away like that, it's because they think their client's instructions are unsustainable.
Increasingly isolated, and, according to multiple courtroom observers,
claiming they illegally gathered information on him, but the whole thing seems to be collapsing right before our eyes, and
losing control of the narrative in real time. This was supposed to be his moment, his reckoning, his stand against the British press. Instead, it's turning into something else entirely. Because as this case unfolds, the story is no longer about tabloid ethics or media intrusion. It's about credibility, judgment, and whether Harry himself helped create the very media ecosystem he now claims destroyed him.
key members of it have jumped ship, resigned. Now, that's not just a minor setback.
And then came the moment that sent shockwaves through the courtroom. His own legal team began resigning, not all at once, not with a dramatic announcement, but quietly, deliberately, and unmistakably. When lawyers walk away mid-case, it's rarely about scheduling conflicts. It's about confidence, or the lack of it.
Rebecca English from the Daily Mail and Katie Nicholl, spelled Nicholl, of criminal behavior. Criminal! For digging up dirt on him and his crew. But Associated Newspapers...
This lawsuit was framed as historic. Harry wasn't just suing tabloids, he was allegedly challenging an entire media culture. The target? Associated Newspapers Limited, the publisher behind the Daily Mail and Mail on Sunday. Harry's claim is that journalists working under this umbrella engaged in unlawful information gathering, including invasions of privacy and illicit tactics stretching back more than a decade. It was positioned as a moral crusade, David versus Goliath, the wounded prince versus the ruthless press. And for a while, that framing worked at least publicly. But courtrooms don't operate on vibes, they operate on evidence. And once testimony began, that narrative started to fracture. The defence didn't just dispute Harry's claims, they reframed him. Instead of portraying him as a passive victim, they argued that Harry was an active participant in royal media culture, someone who engaged with journalists socially, strategically, and voluntarily when it suited him. And then they got specific. Two names became central to the defence's argument: Rebecca English and Katie Nicholl. Harry's legal team alleged these journalists crossed legal lines. The defence responded by saying, "Show us the proof." And when that proof didn't land the way Harry's team expected, the tone of the trial shifted dramatically. Katie Nicholl, a long-established royal commentator, became a focal point. The defence argued that rather than secretly infiltrating Harry's life, Nicholl had been invited into his social world. One moment in particular stunned the courtroom. According to defence submissions, Nicholl was invited to a private party at Kensington Roof Gardens in 2011, allegedly by Harry himself. Not surveilled, not infiltrating, invited. They also argued that after that event, Nicholl and Harry moved in overlapping social circles, exchanging pleasantries in environments that were anything but covert. And when Harry's accusations were put to her, the reported response was blunt. "You invited me." That single line landed like a hammer, because it doesn't just challenge the allegation, it reframes the relationship entirely. If true, this isn't a case of criminal intrusion, it's a case of mutual access. And that distinction matters legally and narratively. Then came the Rebecca English argument. Harry's lead barrister, David Sherborne, presented an email from 2010 involving a request for travel information related to Harry's then-girlfriend, Chelsea Davy. The implication: that English was fishing for private data through improper channels. The defence dismantled that claim, point by point. They argued the email did not demonstrate illegality, nor did it prove unauthorised access. They highlighted English's long career as an accredited royal journalist, with legitimate access during Harry's years as a working royal. In other words, this is how royal reporting worked at the time. What Harry's team framed as sinister, the defence framed as standard industry practice, uncomfortable perhaps, but not unlawful. This is where things reportedly began to unravel. Court observers noted Harry becoming visibly strained. Long pauses, rigid posture, a fixed expression that suggested more frustration than confidence. And then came the quiet exits. Multiple members of Harry's legal team resigned during the proceedings. No dramatic headlines, just gone. One legal analyst summed it up brutally. When solicitors withdraw like this, it usually means the client's instructions are unsustainable, or the evidentiary foundation has collapsed. That's not abandonment of the law, that's abandonment of a version of events. Here's the part that's impossible to escape. Harry has spent years condemning media intrusion, yet he and Meghan Markle have built a global brand by selling unprecedented access to their private lives. Books, podcasts, Netflix documentaries, millions made from telling their story in their words, on their terms. Which raises a question the defence didn't even need to ask out loud. Where does privacy end and monetization begin? You can't simultaneously claim total victimhood while actively curating your own media exposure. Courts notice contradictions like that. So does the public. And then there's the empty chair. Meghan Markle has not been present in court. She's reportedly thousands of miles away, maintaining radio silence. No hand-holding, no public support, no carefully staged unity. For a couple whose brand was built on us against the world, the absence is deafening. Some observers see strategy, others see distance. Either way, Harry is alone in that courtroom, facing not just lawyers, but the collapse of the narrative he's defended for years. At this point, the lawsuit has become something else. It's no longer about what journalists did in 2010 or 2011. It's about Harry's judgment, whether he exaggerated normal media interactions into conspiracies, whether personal grievances blurred into legal claims, whether resentment replaced evidence. The journalists he accused aren't faceless villains anymore. They're professionals with careers, reputations, and in Nicholl's case, a public battle with cancer that has earned sympathy well beyond the courtroom. The optics are shifting fast. Here's the hard truth. Harry tried to fight a legal war using PR logic. He assumed moral framing would outweigh evidentiary scrutiny.
No, Harry, you invited me to come and party with you. Ouch, that's gotta sting. It completely undermines his whole victim narrative, makes it look like he's got a...
But courtrooms don't reward narratives, they reward facts. There's no Netflix edit, no sympathetic voiceover, no selective omission, just cross-examination. And right now, that's not going his way. Harry wanted to be seen as a reformer, a man standing up to entrenched power.
Harry's lead lawyer, David Sherborne, tried to show an email from 2010 where English was supposedly trying to get flight details for Harry's then-girlfriend, Chelsea Davy, Chelseydavy.
Instead, he looks isolated. His legal allies are gone, his public sympathy is thinning, his wife is absent, and his past is being re-examined in ways he can't control. This case may still have chapters left, but already it's a cautionary tale, about confusing publicity with power, about mistaking personal truth for legal proof, and about what happens when a narrative collapses under cross-examination. In the end, Harry isn't just fighting tabloids, he's fighting a version of himself, and right now, the court isn't buying it.
Sherborne argued that this proved she was using illegal methods to get information. But the defense shot that down too.